Well, back when we first started thinking about this, and National Association of Drug Court Professionals was founded, and there were 100 of us at that very first meeting. And then I remember when it was the first 100 drug courts, then the first 500, then the first 1,000, and now there are over 3,500 problem-solving courts in the United States, and this approach is being taken in over 20 countries. So this, if you would have sat me down in 1990 and said, this is the way things are going to be by 2008, I would have said, no way. I mean, absolutely unpredictable that it would have taken off like that. Until you think about it, makes so much sense. And the kinds of things that bring people to court in Japan are the same things that bring people to court in Israel, are the same things that bring people to court in Costa Rica, are the same things that bring people to court in Potash, Idaho. And a brain is a brain is a brain. We have cultural differences, language differences, all kinds of differences, but our samenesses, if you will, for what brings us to court are more important than our differences. So this is a model that can be modified for local legal culture within the United States, within parts of the state. There are differences. Certainly other countries, but the principles are the same. So some of the principles are doing away with the adversarial system. It's not about winning. The win in a problem-solving court is to get the person out of court and to keep them out of court forever. That's the win. To get them being a productive member of society, a good parent, have healthy relationships, be employed, get an education, all the things that help people be productive and contributing members rather than the people who take up vast quantities of resources because of their addictions and other diseases. So that's one principle. Another is a very involved judiciary, not just that neutral person calling balls and strikes. You know, you're right in there. It's almost like a judge's life coach, to use the sort of current nomenclature. Everybody in that courtroom is focused on the individual and how can we change behavior, what can we do that's helpful. So we look at other disciplines. We look at what we know about behavioral change literature, what we know about how many sanctions you should give for how many rewards given. And that, you know, that old phrase that I bet your mother said, because mine did, which was, you can catch more flies with sugar than you can with vinegar. And that's true for human behavioral change as well. And recognizing that change is hard, and what makes a person want to change. What are the motivating factors for behavioral change? How can we encourage this person to keep making choices that are healthy choices? So the focus is just totally different. Another thing is frequent check-ins with the system, either probation officer or judge, depending upon the model. And it's the same principle as Weight Watchers. The reasons things like Jenny Craig and Weight Watchers and all those work is, number one, portion control. Duh. Eat smaller amounts. And number two, you have to go get on that scale on Saturday in front of all those people. It's the same thing as turning in a urine test that's going to be clean or going to show that you use drugs. That is a motivating factor, to have other people watching your commitment and saying, yes, you can do this. And that, I think is a general principle. And the monitoring. So the frequent check-ins, the monitoring through urine tests, if we're talking about alcohol and other drug issues. Counseling. Recognition of co-occurring mental health issues, which we didn't do a very good job of at the beginning of problem-solving courts. When I first started talking about co-occurring disorders, people looked at me like, well, you can't have people with mental health problems in drug court. I said, oh, just like you can't have people with drug issues in a mental health setting, right? So where are these people supposed to go? Because what we're talking about, 60 to 70% of people in one system need the services of the other. And the fact that we even have broken them up with two streams of funding and two sets of criteria and diagnoses is ridiculous. It's all, embedded together. So co-occurring disorders have to be addressed. If you don't do that, they're not going to do well in treatment. Things like recognition of gender differences, cultural differences, language barriers, childcare and the provision of childcare to make it easier for people to get where they need to go. Trauma-informed services, so for women who are survivors of domestic violence, for women who are survivors of childhood sexual abuse, incest, rape. And also our returning veterans are returning with huge numbers of cases of post-traumatic stress disorder. And that's really being recognized and starting to be addressed a little bit, but nobody ever expected it to be in the volume that it is. And Robert Russell, who's one of the early drug court judges up in Buffalo, New York, just started the first Veterans Court, recognizing over a year's time that so many of the people who were coming and getting in trouble in his regular criminal calendar were vets just home from Iraq or Afghanistan, and saying, okay, so what's going on here? And, the mess that they've been making of the Veterans Administration and the underfunding, the voting against benefits, all the things that have been going on, I hope get corrected real soon, because you can't ask somebody to go and do that and then not take care of them when they come home. And they're coming home with substance abuse and other mental health issues. That's just part of war. Well, the first were the drug treatment courts, the first to recognize and employ this model. Then I believe second was probably a toss-up between mental health courts and domestic violence courts. Mental health courts, which is not to say that those folks don't often have a substance abuse issue as well, but it's really which is the primary diagnosis and which is the most severe, the substance abuse or the mental health, and that's how you get pegged one for the other. What I point out when I'm teaching is actually those courts are co-occurring courts. Every court's a co-occurring court. Domestic violence, two focuses there. First on the survivor, to make sure she's safe and the community's safe, because so often the violence spills over from the targeted person to her surrounding people, and oftentimes the children as well. And also focusing on the perpetrator to change his, most often his, behavior. So there's two things going on in the focus of a domestic violence court. There's homeless courts. There's, in the family law setting, unified family courts. There's juvenile courts that focus on the teenager or younger child who is having alcohol or other drug problems, as well as child abuse and neglect. And the parents are the ones with the substance abuse issues, and the children are in bad shape because of that. So it's really permeated all kinds of areas. I think there's currently 14, 15 kinds of courts. There's peer courts, which are teenagers who are sitting in judgment of other teenagers. They're usually tougher than any juvenile judge, and often start the sentence with an apology. You must write an apology to whomever you've harmed, which of course is one of the principles of restorative justice. So they've incorporated all these different sectors of the problem-solving court movement in different ways. So I think there's like 14 or 15 identified kinds of courts now that are employing these methods.